SHRM-CP question of the day from PrepSolution's complete bundle lives in the organization domain under technology management. It tests one of the most counterintuitive concepts in global HR, a GDPR compliance program, signed consent forms from every employee, and a rollout that still has to be stopped. Because consent means something very specific in European data law. And in the employment context, it almost never means what HR thinks it means. The rule is this: no free refusal, no valid consent. Here's the scenario. A new safety initiative at a German manufacturing plant involves integrating employee RFID badges with the plant control system to track real-time operator movements. The local IT manager provides signed consent forms from every affected employee to comply with GDPR. You review the implementation plan. What is the required next step regarding data privacy compliance? Option A, approve the integration. Explicit written consent from the workforce satisfies the primary lawful processing requirement under GDPR. Option B, halt the implementation. Employee consent is generally deemed invalid under GDPR because of the employer power imbalance, requiring a different lawful basis. Option C, authorize the project. Routine safety monitoring on an industrial control system automatically qualifies as a vital interest exception under GDPR. Option D, reject the integration. GDPR strictly prohibits processing employee tracking data on operational technology networks unless the servers are physically isolated. Pause here, pick your answer. Ready? 3 of these answers read the GDPR too fast. Only one reads the power dynamics. The correct answer is option B. Halt the implementation. Find a different lawful basis. Here's the test the scenario is actually asking you. Can the employee refuse without any detriment or fear of detriment? Because if the answer is no, or even probably no, the consent was not freely given. And consent that is not freely given under GDPR is not consent at all. No free refusal, no valid consent. Here's the legal anchor. GDPR. Article 6 lists 6 lawful bases for processing personal data. Consent is one of them. But the Article 29 Working Party, the European regulators themselves, have held consistently that consent is rarely valid in employment. The reason is structural. Think of it like your boss asking for a voluntary donation to their kid's fundraiser. Can you say no? Technically, yes, but will you? The power imbalance poisons the consent. The signed form on top is decoration. The underlying pressure is the substance. So what are the valid lawful bases for workplace monitoring? Legitimate interest under Article 6(1)(f) with a proportionality analysis. Legal obligation under Article 6(1)(c) if the processing is required by another law. Performance of contract under Article 6(1)(b) if monitoring is necessary to the employment contract. And in Germany specifically, a formal works council agreement. Any of these 4 can replace consent in this scenario. Consent alone cannot. Here's the deeper legal layer most candidates miss. Germany adds a second hurdle on top of GDPR. The Works Constitution Act, Section 87. It gives the Works Council co-determination rights over any technology the employer uses to monitor employee behavior or performance. RFID location tracking falls squarely in that scope. Even if HR finds a valid GDPR lawful basis, the Works Council must still agree, not be consulted, agree. The signatures from IT do not substitute. So what does HR do next? Halt the rollout. Do not proceed on the strength of consent forms. Identify a new lawful basis, legitimate interest, or legal obligation supported by a proportionality analysis. Run a data protection impact assessment under GDPR Article 35. High-risk monitoring requires it. Engage the Works Council formally with negotiation time budgeted. Now, why the other 3 options fail? Option A, approve on the strength of consent forms. GDPR consent must be freely given. European regulators have repeatedly held consent from employees is rarely valid because the employment relationship creates pressure to agree. Signed forms do not cure the power imbalance. No free refusal. No valid consent. Option C, rely on vital interest. The vital interest basis at Article 61D is strictly interpreted. It covers immediate life or death emergencies where the data subject cannot give consent, not routine occupational safety monitoring. Applying it here would fail regulatory scrutiny. No free refusal. No valid consent. Option D, reject because of network architecture. GDPR requires appropriate technical and organizational security measures, but it does not dictate specific network designs, such as mandatory physical isolation of operational technology systems. The argument misreads the statute entirely. The pattern to remember: on any GDPR consent question in the employment context, ask whether the employee could realistically refuse without fear of detriment. If the answer is anything other than a confident yes, consent fails. Find a different lawful basis. Want to pass SHRM-CP the first time? PrepSolution gives you 1,500 practice questions, 3 full mock exams, 600 flashcards, and the SJI Strategy Masterclass. Get it at prepsolution.com/exam/SHRM-CP. Thanks for watching. See you tomorrow.